This is part 7 of the Sean Williams story. If you haven't seen parts 1 through 6, I have a whole series on my YouTube channel. The links will be in the description for you to get over there. But if you're ready for part 7, hit the like button and let's get into it. By now, we're caught up to speed with Sean Williams being in custody. He's under arrest, and it seems like there's some good evidence that he may have violated over 50 people. He's tried to escape from prison 2 different times, allegedly. But in here, what we're going to look at today is Mikayla Evans' lawsuit. This will be the 3rd lawsuit filed against Johnson City and different Johnson City Police Department officers for failing to protect victims and possibly ignoring an extortion scheme for an active cover-up. You probably remember Mikayla Evans as the woman that fell from Sean Williams' 5-story apartment building window, and mysteriously nobody really knew what happened. She was sedated for 3 weeks in the hospital while she recovered, and when they did the same test, the SA testing kit that they do at hospitals, they never tested her for drugs in her system. We're going to look at Mikayla Evans' lawsuit in full, but before we do that, I want to look at this response, the statement from Johnson City. Johnson City, in response to Mikayla Evans' lawsuit, says, "These claims are related to incidents from nearly 4 years ago, and the allegations are largely the same as those we continue to deny in our other litigation. We have yet to see any evidence that supports allegations of corruption by the Johnson City Police Department and continue to welcome any investigation that could dispel such claims." So let's get into this lawsuit then. It's going to take us all the way back to 2020, and this was filed in U.S. District Court for the Eastern District of Tennessee, the Greenville Division, and the parties named are Johnson City, Carl Turner, individually and in his capacity as Chief of Johnson City Police Department, Kevin Peters, individually and in his official capacity as Captain of the Johnson City Police Department. Now, both of these are retired. Carl Turner and Kevin Peters, I remember, are retired. Thomas Sparks, individually and in his official capacity as investigator of the Johnson City Police Department. Justin Jenkins, individually and in his official capacity as investigator of the Johnson City Police Department. Jeff Legault, individually and in his official capacity as investigator of JCPD. And Brady Higgins, individually and in his official capacity as investigator for Johnson City Police Department. They're also naming does 8 through 10 inclusive, which means if we find out more during discovery, maybe need to add a party later on, we're leaving this open. So what are the factual allegations? So beginning in 2018, at the latest, and continuing until his escape in 2021, Sean Williams, with the aid of defendants, conspired with Alvaro Fernando Diaz Vargas, and I wonder if this is the friend, and others to drug, assault, and sexually exploit women and minors in his downtown Johnson City apartment. These crimes occurred despite defendants' knowledge of the same. At all times relevant herein, Williams lived in a 5th-floor apartment located in downtown Johnson City. Williams operated Glass and Concrete Contracting, LLC, along with his accomplice Diaz Vargas. There you go. Williams and others used Glass and Concrete Contracting, LLC, as a front to buy and sell narcotics. Williams developed a modus operandi by which he attracted, drugged, and raped women. First, he would meet young women, often using the aid of young male associates to identify the women. Once the women consumed the alcohol and/or coke provided by Williams, they would pass out. Once the women regained consciousness, they would discover they'd been SA'd. Williams was allowed to continue this pattern of criminal behavior without consequences by bribing defendants working for the Johnson City Police Department to prevent investigations and/or cover up evidence of his crimes. Williams has an extensive criminal record from 1989 to 2004. Except for a few North Carolina criminal charges in 2009 and 2013, and remember that's where he ends up getting arrested, passed out with a bunch of stuff in his car, in his van. Some university police officers find him. Williams' criminal record drastically declines once he moves to Johnson City in late 2004, likely because of his conspiratorial relationship with defendants, manifested through illegal bribes. Interesting argument. And it might make sense. He moves to Johnson City in 2004, but we know he was in North Carolina with a van full of stuff. So maybe he used to run. Maybe he used to just drive down the interstate, get over to wherever he was going to in North Carolina, and happened to get picked up twice already. But as far as while he's actually in Johnson City, his record's just suddenly quiet. Interesting argument. Defendants did not investigate, arrest, or charge Williams when women reported being drugged and raped by Williams. Instead, defendants accepted a weekly bribe of at least $2,000 from Williams' accomplice. Defendants willfully ignored reports, intimidated and belittled the victims, and discouraged pursuit of legal remedies because of Williams' weekly bribes. Williams continued trafficking guns and drugs, drugging and raping women, and exploiting children for years because defendants failed to investigate, arrest, or charge Williams. As a result of defendants accepting the bribes and turning a blind eye, plaintiff was drugged by Williams and pushed by him out a 5-story window, sustaining life-threatening injuries on September 19, 2020. So plaintiff was drugged, and she was pushed by him. And personally, I believe it because of the modus operandi, right? I believe it because of the context. But when it initially happened, she said she wasn't sure. She said she didn't know. And that all she knew was that she was afraid of heights and would never get that close to a window, especially on the 5th floor. And what sucks for her is the same people, the same organization that should have been investigating this part. I mean, all of it, but they really had the power. You know, if Williams is just going to say, I didn't push her, and then he deletes the camera footage that faces the window, the evidence might be gone if there were no other witnesses. This part, we would have evidence, we would have a record, we would have a drug report. We would have a report from the hospital, from the SANE test, that said this stuff was in her system or nothing was in her system. And we don't have that at all because the very defendants that are being sued here didn't do their jobs, namely Thomas Sparks. It's an interesting spot to be in. It's an unfortunate spot to be in, that what could and should be available to either prove or disprove this was not collected by the defendants, even though they were the ones that should have collected it. So on or about June 23rd, 2022, Special Assistant United States Attorney Kateri Lindahl initiated a civil action against defendants for her unlawful firing. Dahl alleges her termination was a result of her insistence on investigating Williams, an investigation that defendants had a vested interest in preventing, as it likely would uncover their unlawful actions in protecting Williams. And we got to look through one transcript of a meeting between Captain Peters and former Chief Carl Turner. They're both retired now, but that was an interesting transcript. It wasn't like anything blatantly inculpatory was in there, right? But it was interesting the way that they were suggesting and the reasons they gave as to why they didn't want to push for an investigation or allow Kateri Dahl to push for an investigation into Sean Williams. I believe we looked at that at maybe part 5. Following Dahl's complaint on June 21st, 2023, another civil complaint was filed against defendants by a handful of Williams victims, alleging among other things that defendants intentionally failed to investigate Williams in exchange for weekly bribes. On September 6, 2023, an amended class complaint was filed, alleging in detail the affirmative acts taken by defendants after plaintiffs' fall to cover up and protect Williams from charges related to the incident. A second amended class complaint was filed on March 1, 2024, bringing additional allegations. The complaints collectively herein referred to as the class complaint. Now we're going to look at details of Mikayla's incident. On September 19, 2020, plaintiff was out in downtown Johnson City with a couple of friends. Plaintiff had consumed a couple of beers but was not intoxicated. She was supposed to meet her friend Albert Watts in the downtown Johnson City bar, Wonderland Lounge and Grill. While waiting for Albert at Wonderland, Albert texted plaintiff and told her he could not find the bar. Plaintiff decided she would meet Albert and walk with him to Wonderland. When plaintiff walked down the street outside of Wonderland, she found Albert standing outside of Williams' garage, watching Williams and 2 individuals partying inside. Once plaintiff walked up to Albert, she noticed loud music and lights coming from the garage and mentioned to Albert that it looked like a fun time. Plaintiff then heard a voice from inside the garage say, "Come in! Come on in!" After further encouragement from Albert, the 2 of them entered Williams' garage. Within 20 minutes of arriving at the party, plaintiff began feeling the effects of a drug, and her speech began to slur. Shortly thereafter, by information and belief, Williams invited plaintiff and Albert to his apartment across the street. Though plaintiff has no memory of entering Williams' apartment, surveillance footage shows plaintiff, Williams, and Albert entering Williams' apartment. At approximately 2:34 a.m., upon information and belief, Williams attempted to essay plaintiff and during this altercation, pushed plaintiff out of his 5-story apartment building window. Soon after plaintiff was pushed, and before he could speak to law enforcement, Albert fled the scene. Plaintiff was admitted to the hospital and underwent multiple surgeries. Plaintiff's injuries included pelvic fracture, humeral fracture, radius fracture, dislocated elbow, calcaneus fracture, talar neck fracture, multiple metatarsal fractures, fibular avulsion, navicular fracture, calcaneus fracture, fibula fracture, cuneiform fracture, cuboid fracture, multiple facial and skull fractures, and multiple lumbar fractures, Upon admission to the hospital, plaintiff was intubated. And I do also want to point out that Mikayla Evans had made a Facebook post mentioning that this detail here is actually, it's a bit different. So she was actually intubated on scene and not at the hospital. So I don't know if there's an amended version of the complaint because the one I grabbed, it was published in June. But this correction from Mikayla through a Facebook post came on July 14th. And I really don't know anything about emergency medicine, but I would imagine all of this stuff going on, I can imagine why intubation might be necessary right away. But here it does say that upon admission to the hospital, plaintiff was intubated because she was in respiratory failure. Plaintiff was discharged from the hospital on October 16th, 2020. However, plaintiff would be bedridden and unable to care for herself until the summer of 2022. And you can see, we've seen current pictures, she still walks with a cane. At the hospital, JCPD did not allow plaintiff to be tested for date-rape drugs, despite multiple requests by plaintiff's mother. Wow, so the mom was asking. Plaintiff's grape kit was not properly administered. Plaintiff's blood was sent to the crime lab for analysis, but plaintiff did not receive the toxicology report until about 1 year later. And we've looked at some statistics about this, thanks to the Daigle Law Group report, where this is pretty much, normal. Sometimes victims don't even hear back from the detective investigating their case. They don't get calls back. So, about 1 year later, at which point the blood was already destroyed, defendant Sparks, Thomas Sparks, received the toxicology report on or around January 19th, 2021. Defendant Sparks emailed the toxicology report to plaintiff on or around January 20th, 2022. The blood was destroyed on or around September 1st, 2021. JCPD actions. On September 19th, 2021, following plaintiff's fall, JCPD arrived with other first responders to investigate the incident. Now, I think this is an incorrect date. And this is JCPD actions, and I think we have an error with the date because this was supposed to have happened in 2020. But here it says on September 19th, 2021, following plaintiff's fall, JCPD arrived with other first responders to investigate the incident. So presumably this is supposed to be 2020, and that's a significant typo there. According to the government's response to Williams' motion to suppress in the now dismissed felon in possession of ammunition case, see United States v. Williams, defendants Sparks and Jenkins arrived at Williams' apartment on September 19th, 2020. Okay, so we do get it correct here. That's good. Sometime after the first JCPD officers arrived on the scene. The two officers shouted up to Williams' apartment from the street, asking to be let in, and eventually obtained the passcode to enter the apartment from someone on the scene. After obtaining entrance to Williams' apartment, defendant Sparks and Jenkins took control of interviewing Williams and securing any digital evidence stored on Williams' cell phone, which was linked to cameras throughout Williams' apartment. Defendant Sparks escorted Williams to JCPD headquarters. Defendant Sparks and Jenkins interviewed Williams at JCPD headquarters. During the 30-minute interview, defendant Sparks and Jenkins allowed Williams to keep his cell phone, which had access to the video surveillance cameras in his apartment. After the interview, defendants left William alone with his cell phone. Per the government's response, Williams manipulated his cell phone, made phone calls from his cell phone during this time, and erased all the data from his cell phone. After this, defendant Sparks seized Williams' cell phone and applied for a search warrant for Williams' apartment to search for evidence of Tennessee Code annotated 39-11-106, attempted criminal homicide. So during this time, Williams' apartment was left unsecured. Per the government's response, when JCPD officers returned to execute the search warrant on September 19th, 2020, the video surveillance cameras, which were observed hours before at Williams' apartment, had been removed and hidden in a closet under paper towels. JCPD officers seized 4 phones, 4 computers, and 3 memory cards from Williams' apartment. Upon information and belief, the digital devices remained in the custody of JCPD for over 2 years without being searched for evidence. JCPD officers did not arrest Williams on September 19, 2020. Williams fled from Tennessee in May of 2021. In a recent opposition in response to a motion to quash filed in the case Jane Doe's 1-9 v. City of Johnson City, bank records have been produced showing Williams had an accomplice named Female 4 that withdrew at least $2,000 a week from Williams' various shell companies and paid defendant Sparks and other investigators. By information and belief, defendant Sparks and the other investigators were paid through the summer of 2022. And now we have to counter, we saw the statement already from Johnson City, but I'm guessing that here in this section we're going to see a counter of why we're filing this now. So we've already seen the response say, she's bringing this up 4 years later. So here, Plaintiff could not have learned of JCPD's intentional failure to investigate Williams following her fall until the first amended class complaint was filed on September 6, 2023. A lot of it was kept under seal as well. So plaintiff learned of the defendant's intentional mishandling of her investigation no earlier than the filing of the first amended class complaint on September 6, 2023. Although before this date, plaintiff was aware that the JCPD failed to bring charges against Williams related to the incident, and that JCPD even indicated as early as September 21, 2020, 2 days after the incident, that they did not suspect foul play. Plaintiff believed JCPD was investigating the incident. She had no knowledge that JCPD intentionally failed to investigate Williams to protect both Williams in exchange for bribes and themselves from being discovered for accepting these bribes. Plaintiff was not aware that Williams was, quote, untouchable because he had been bought off by JCPD. In fact, plaintiff trusted JCPD and specifically defendant Sparks to investigate her fall. She continued to cooperate and speak to Sparks about the investigation until Sparks stopped returning her phone calls over a year after the incident. The class complaint revealed JCPD officers arrived at Williams' apartment shortly after the incident occurred that night. According to the government's response to Williams' motion to suppress in the pending felon in possession of ammunition case, Detective Sparks arrived sometime thereafter with another JCPD officer, Justin Jenkins. The two officers shouted up to Williams' apartment from the street, asking to be let in, and eventually obtained the passcode to enter the apartment from someone on the scene. Inside the apartment, Williams showed Detective Sparks and Officer Jenkins video clips taken from cameras positioned around his apartment, including a camera facing the entrance door to the apartment and a camera facing the elevators. Not the window in question. Williams used his cell phone to show these videos to the officers and even offered to text the videos to Officer Jenkins. Williams claimed that the video cameras inside his apartment, which pointed towards the windows out of which plaintiff fell, were not recording on September 19, 2020. While at Williams' apartment on September 19, 2020, defendants took Williams' safe, which kept $500,000, $500,000. When the safe was returned to Williams, only $81,000 was left per the class action complaint. Now, that class action complaint cites a Facebook post that was made on Sean Williams' Facebook page and claims that Sean Williams made against the police during the course of his cases. So ultimately, the source of this claim that there was $500,000 and then there was only $81,000 was Sean Williams. Defendants likely took the money as payment for not investigating Williams for his actions on September 19, 2020. On information and belief, shortly thereafter, Williams told the officers to leave the apartment. Rather than secure Williams' apartment, or any of the digital media which may have contained evidence, while they sought a for the attempted homicide investigation, JCPD officers left. After the officers left, on information and belief, Williams and/or Diaz-Vargas moved and hid firearms and illicit drugs located throughout the apartment. Williams and/or Diaz-Vargas placed the items in a duffel bag and moved them to the roof. According to the government's response, later that morning at approximately 4:17 a.m., Detective Sparks and Officer Jenkins interviewed Williams at JCPD headquarters. Sometime before this interview, the exact time is not stated in the government's response, Detective Sparks offered to drive Williams to JCPD headquarters from Williams' apartment downtown. Williams agreed. Detective Sparks then gave Williams a ride in his car. Williams was not handcuffed, and he rode in the front passenger seat next to Sparks. There is no record in the government's response, nor in the affidavits of Detective Sparks, of what the two spoke about during this ride. Williams' interview at JCPD headquarters was video recorded. At approximately 4:17 a.m., Williams was placed in an interview room. The door was left open, and Williams was not handcuffed. Even though Williams had just shown Detective Sparks digital evidence of the crime under investigation on his cell phone, demonstrating to Detective Sparks that Williams could access, and therefore likely manipulate, the camera footage from his phone, the officers permitted Williams to retain possession of his cell phone for the next 30 minutes while he sat in the interview room. From 4:17 a.m. to 4:20 a.m., Williams was alone in the interview room with his cell phone while Officer Jenkins got paperwork together. Once the interview began at approximately 4:20 a.m., Officer Jenkins closed the door. Officer Jenkins and Williams began to speak about whether the surveillance cameras captured video of plaintiff falling. Williams continued to maintain possession of a cell phone throughout this conversation. Williams then told Officer Jenkins that he could text Jenkins the videos he had previously shown them, Officer Jenkins and Detective Sparks. Officer Jenkins asked Williams to email the videos instead. Williams stated he believed he could email the videos and proceeded to look at his cell phone. According to the government's response, Williams became distracted while looking at his cell phone. He then told Officer Jenkins that he could not find any videos of plaintiff falling. Based on the timeline provided in the government's response, it appears that Williams spent the next several minutes manipulating data on his cell phone while Officer Jenkins watched and took no action. Approximately 8 minutes into their conversation, Officer Jenkins asked Williams for a statement about the incident. Officer Jenkins then read Williams' Miranda warnings. Williams remarked that he thought it was strange that he was being read his rights. Officer Jenkins told Williams that he, Williams, was not under arrest, and Officer Jenkins was simply reading Miranda warnings because he, Jenkins, was going to ask questions. Williams asked for a lawyer to be present, but then stated that he would give a statement and he would not answer questions. Officer Jenkins told Williams that they needed to come to an agreement before they could proceed with an interview. Officer Jenkins provided Williams with the written Miranda waiver for review, but Williams did not agree to sign it and instead asked for his lawyer. At approximately 4:35 a.m., Officer Jenkins left the room, continuing to allow Williams to maintain custody of his cell phone. For the next 6 minutes, Williams spoke to several people on the phone while purportedly attempting to call his lawyer. According to the government's response, at some point, Williams stated to someone over the phone that since he could not contact his lawyer, he would just leave and come back to speak to the investigators later. At approximately 4:41 a.m., Williams knocked on the door of the interview room. Detective Sparks opened the door. Williams told Detective Sparks that he needed a charger for his phone so that he could call his attorney. Williams then asked what they would do if he could not contact his lawyer. Williams and Detective Sparks then discussed whether Williams wanted to speak to them without a lawyer. At this point, over 30 minutes into Williams' interview and approximately 2 hours after Williams' first encounter with JCPD police on September 19, 2020, Detective Sparks seized Williams' cell phone. Detective Sparks then told Williams that he was getting a search warrant for its contents. According to the government's response, Detective Sparks and Williams then argued over whether Detective Sparks could seize Williams' cell phone. Williams asked whether Detective Sparks would give him a ride home, and Detective Sparks agreed to drive him home. At approximately 4:46 a.m., Detective Sparks told Williams he would be right back. At approximately 4:51 a.m., Williams opened the door of the interview room and asked to leave. Williams asked for his cell phone, but he was told it had been seized pending a search warrant. At some point thereafter, the government's response does not state the time. Williams left JCPD headquarters and walked back to his apartment. Then he just walks. Okay. At 8:52 a.m. on September 19, 2020, Detective Sparks applied for a warrant for Williams' apartment to search for evidence of Tennessee Code annotated 39-11-106, attempted criminal homicide. According to Sparks' September 19, 2020 affidavit in support of this warrant, JCPD officers powered off Williams' cell phone at some point that morning and then powered the phone back on after Williams left, with the intent to place the phone in airplane mode. The affidavit goes on to state, when the phone was powered on, it had a message displaying that it was lost, which would suggest that Sean Williams has access to other devices in the residence that could be connected to the camera system. In his affidavit, Detective Sparks then sought permission to seize video surveillance cameras, video surveillance storage devices, any electronic device capable of connecting the camera system, including but not limited to cell phones, computers, tablets, and personal digital assistants, any trace evidence that would suggest an assault or struggle occurred. In the September 19, 2020 affidavit, Detective Sparks failed to include any information about the 45-minute interview which he had with Officer Jenkins. Okay, well, that's weird. Nor did Detective Sparks explain that he had permitted Williams to retain custody of his cell phone during the entirety of this interview. You're filing the affidavit looking for a search warrant, but you're not going to include any information about a police interview with you and another officer present? When JCPD officers returned with a search warrant at approximately 10 a.m. on September 19, 2020, they seized a number of digital devices from Williams' apartment, including 4 phones, 4 computers, and 3 memory cards. According to the government's response, JCPD officers seized, among other items, video cameras which had been hidden in a closet under paper towels. The video surveillance cameras which officers had observed hours before in the apartment had all been taken down while JCPD had left the apartment unsecured. On information and belief, the digital devices seized on September 19, 2020, remained in the custody of JCPD for over 2 years without being properly searched for evidence. By information and belief, had JCPD officers properly secured, seized, and searched the digital evidence in Williams' apartment that night, they would have found evidence that Williams drugged plaintiff and caused her fall. To date, no charges have been filed against Williams as a result of the attempted homicide investigation. So that's a lot. I mean, we have the details about the friend that wanted to party, and then disappeared by the end of the night, just fled. And they're not named. They might be called as a witness, but maybe that person, we don't know their name or location. We don't know where they are anymore. Maybe Mikayla never heard from them again. Maybe they were one of the young guys that finds people as part of the MO. We've got the other assistant helping to move stuff on top of the building, allegedly. We've also got some interesting information about how this interview took place, even though it wasn't mentioned in the affidavit. And so now we're going to get to causes of action. So count 1 is under the Tennessee Governmental Tort Liability Act. And here, before plaintiff was pushed out of Williams' 5th-story apartment window, defendants received numerous reports of women drugged and raped by Williams and failed to investigate, arrest, or charge Williams. Chief Turner, Captain Peters, Investigator Higgins, and Investigator Sparks were aware of numerous complaints of SA and drugging by Williams. Despite this knowledge, Chief Turner, Captain Peters, Investigator Higgins, and Investigator Sparks failed to investigate Williams, refer all reports of his criminal activity to the DA's office, or provide protection for the plaintiff in this case. These actions do not exercise the care that a reasonable or prudent individual in their capacities would hold. Chief Turner, Captain Peters, Investigator Higgins, and Investigator Sparks' negligent actions were the proximate cause of the plaintiff's injuries, including bodily injury, emotional distress, deprivation of property, and economic harm. Had defendants properly investigated Williams after any of the reports made against him prior to the incident involving plaintiff, she would not have suffered the injuries alleged in this case. And how do you feel about this? Because he's got a trial coming up where he's facing counts relating to a multitude of victims. And again, this stuff stems for years before where we are now. We also have the Jane Doe, the civil lawsuit. One class that's part of that is saying, look, we reported to Johnson City Police Department incidents involving a different perpetrator, and they didn't listen to us. But like Jane Doe's, at least 1 through 9, are all alleging that they reported specific activity perpetrated by Sean Williams that was ignored by JCPD. And a lot of those Jane Doe's, 2019 and early 2020. So if one of them had been listened to, one of them had been properly investigated, even if just one arrest had been made, and Williams was in custody or tried, she could have been protected. Mikayla Evans could have been protected. This might not have happened. So depending on what can come in, is there enough to make the grounds that, there's proximate cause here? Defendants intentionally failed to preserve the video surveillance cameras found in or near Williams' apartment when plaintiff was pushed out of Williams' window, and intentionally failed to preserve the evidence on Williams' cell phone. Defendants intentionally failed to prevent Williams from destroying evidence on his cell phone while in police custody after plaintiff fell out of Williams' window by not seizing Williams' cell phone before he was left alone in the interrogation room. Defendants intentionally failed to block off Williams' apartment while waiting for a warrant to begin searching the apartment, and as a result, defendants intentionally failed to prevent Williams and others from re-entering his apartment and removing or destroying evidence. Defendants failed to test plaintiff for date-grape drugs and failed to complete a grape kit. Defendants intentionally delayed emailing plaintiff for toxicology report until after the blood was destroyed. And I've got to do my homework here. So is there something like maybe they hold the blood for a 1-year period? And in waiting, in delaying this email with the toxicology report, it could have been a strategy. It may have been a strategy to say, hey, you're not going to think that toxicology report is accurate, but too bad, so sad. The blood that you would need to get retested has now been destroyed. I think we're getting at something like that here, but I don't know the specifics for sure. If this were to go to a trial, I'm sure it would be explained to the jury. Defendant City is liable for the injuries proximately caused by negligent acts or omissions of Chief Turner, Captain Peters, Investigator Higgins, and Investigator Sparks in failing to investigate Williams prior to the incident involving plaintiff. Johnson City is liable for the police officer's acts of destroying the evidence against Williams and the omission of failing to preserve the evidence and failing to investigate Williams, both before and after the incident involving plaintiff. Count 2 is civil conspiracy. So defendants intentionally conspired together, conspired with Williams, and conspired with Williams' other co-conspirators by agreement and understanding to further Williams' acts, destroy evidence against Williams, and obstruct the investigation into Williams for years, including Williams' acts against plaintiff on September 19, 2020. Williams paid defendants weekly not to investigate Williams per the plaintiff's opposition in response to a motion to quash in the class action suit filed by Williams' victims, Jane Doe's 1 through 9 v. City of Johnson City. While at Williams' apartment on September 19, 2020, defendants took Williams' safe, which kept $500,000. When the safe was returned to Williams, only $81,000 was left per the class action complaint. Defendants likely took the money as payment for not investigating Williams for his actions on September 19, 2020. Defendants intentionally and purposefully did not collect evidence against Williams and did not review seized evidence from Williams' apartment, and did not investigate Williams further after plaintiff was pushed out of Williams' window because they conspired with and received payment from Williams. As a result of defendants receiving the bribe and failing to investigate, arrest, or charge Williams, Williams continued his crimes, drugged plaintiff, and pushed her out of his apartment window, resulting in life-threatening injuries to plaintiff. Count 3 is fraudulent concealment. Defendants intentionally concealed information from plaintiff. Defendant Sparks intentionally withheld plaintiff's toxicology report until after plaintiff's blood was destroyed. Defendants intentionally did not review the surveillance cameras in and around Williams' apartment despite knowing of their existence. Plaintiff could not have obtained the toxicology report or the video surveillance from Williams' apartment by any other means than through defendants, because both were in defendant's custody or control. Defendant Sparks had knowledge of the facts because Defendant Sparks was one of the lead investigators on plaintiff's fall on September 19, 2020. Defendant Sparks was aware of the surveillance cameras in and around Williams' apartment. Defendant Sparks was aware of the toxicology report because he received it a year prior to emailing the report to plaintiff. Sparks intentionally waited until 4 months after the blood was destroyed to send it to plaintiff. The lab provided Sparks with the date that the blood would be destroyed on the toxicology report. There you go. Defendant Sparks knew plaintiff's blood would be destroyed when he received the toxicology report. Defendant Sparks intentionally emailed the toxicology report to plaintiff 4 months after the blood was destroyed. Count 4, equal protection, unconstitutional pattern and practice as to women reporters. So all of the same things that we've seen already. And as a result of these things, defendants recklessly disregarded plaintiff's equal protection rights because of defendants' acceptance of bribes and persistent and widespread denial of law enforcement services. Plaintiff suffered economic harm, bodily injury, and emotional distress because defendants allowed Vic Williams to continue his acts against women. Count 5, equal protection 42 U.S.C. 1983, violation of substantive rights to due process. The defendant's aforementioned actions, including but not limited to the actions of defendants Chief Turner, Captain Peters, Investigator Sparks, Investigator Jenkins, Investigator Higgins, and Investigator Legault, shock the conscience, in that they acted with deliberate indifference to the constitutional rights of plaintiff, with a purpose to harm that was unrelated to any legitimate law enforcement objective. Defendant's actions caused an increased risk to plaintiff and exposed plaintiff to an act of violence by a third party. By receiving a bribe from Williams and failing to investigate, arrest, and charge Williams, defendants exposed plaintiff to the injuries she sustained on September 20, 2020. Defendant's conduct was willful, knowing, wanton, malicious, and conducted with reckless disregard for plaintiff's rights and safety. As a result, plaintiff was deprived of her equal protection rights. As a direct and proximate result of defendant's actions, plaintiff suffered extreme pain and injury in the form of economic harm, bodily injury, and emotional distress. And then count 6, intentional infliction of emotional distress. So, they intentionally and recklessly disregarded plaintiff's case, failed to investigate it, arrest or charge Williams, and then also intentionally destroyed relevant evidence in their custody and control. Defendant Sparks intentionally withheld the toxicology report from plaintiff until after plaintiff's blood was destroyed by the lab. During the time defendant Sparks had the toxicology report, plaintiff continued to call defendant Sparks for updates and copies of all relevant documents available. However, defendant Sparks intentionally did not disclose and withheld the toxicology report for months. Defendants intentionally allowed Williams to keep and use his cell phone in their custody. By allowing Williams to keep his cell phone while in defendant's custody, Williams destroyed video surveillance showing plaintiff being pushed out of Williams' window. Defendants knew this evidence was critical for future legal proceedings. Otherwise, the video surveillance would not have been destroyed. Defendants' intentional and reckless actions by choosing not to investigate, arrest, or charge Williams for his crimes, and intentional destruction of evidence, including evidence of Williams pushing plaintiff out of a 5-story window, in exchange for bribes, is extreme and outrageous and not tolerated by civilized society. As a result of defendant's intentional and reckless actions during the investigation of plaintiff's fall, plaintiff has suffered and continues to suffer from emotional distress. Defendants knew, or should have known, that their intentional actions during the investigation of plaintiff's case would cause plaintiff emotional distress. And so prayer for relief. What are we seeking? So enter judgment against defendants and in favor of plaintiff. Award compensatory damages for physical injuries, medical bills, emotional distress, pain and suffering, and all compensatory and economic damages caused by the actions of defendants. 3. Award punitive damages. 4. Award reasonable attorney fees and costs. 5. Pre-judgment and post-judgment interest. 6. Any other relief and reward to which plaintiff may be entitled. And 7. Any other relief and award the court deems just and proper. Respectfully submitted on the 20th day of June, 2024. And here this is signed by Ashley Beer Vineyard, who practices at DZ Law. So there you go, you guys. That is Mikayla Evans' lawsuit against Johnson City and several JCPD members, former and current. A lot of mention there about Detective Thomas Sparks. And don't forget, we also found out from the Jane Doe lawsuit that there's apparently a federal probe into Johnson City's police and the purported cover-up. The revelation that lawyers for Williams' alleged victims are cooperating with a federal criminal probe are contained in a short footnote. So those footnotes are important. In filings that seek to push back against subpoenas served on some of the women filing suit. Attorneys for former Johnson City Police Captain Kevin Peters, named as a defendant in the lawsuit, sent a private investigator to the women's homes and workplaces to serve subpoenas that are seeking years of their emails, social media messages, notes, text messages, and other documents, including any exchanges they had with Williams. All of the women who filed suit understood their identities to be confidential and were alarmed at the surprise visits, legal filings said. The women's lawyers said they appeared intended to chill survivors in their pursuit of justice, and noted that Peters had the opportunity to serve subpoenas through the women's attorneys or the court instead. The women's attorneys, Vanessa Baird Jones, Heather Moore Collins, and Elizabeth Kramer, referenced the federal corruption probe in the footnote that said they had shared hundreds of documents with federal prosecutors and were willing to do a search of those documents for information sought in the subpoenas. Attorneys for Peters, Captain Peters, defended hiring the private investigator to serve subpoenas and said they were served on 6 women originally named as Jane Doe's when the lawsuit was first filed, along with the parents and sisters of a now deceased alleged victim. The individuals have since been folded into the unnamed class of alleged victims who have joined the suit. While unnamed members of a class action suit are typically not served individually with subpoenas, Peters' attorneys argued the women were active and public participants in the case and claimed that their attorneys had failed to comply with previous document requests. These individuals who filed a lawsuit against these civil servants, accusing them of corruption, and who claim a pattern of intentional discriminatory conduct based upon their own experiences, are not immune from discovery in this case, Peters' attorneys wrote, citing a press conference at which the women appeared in March. The press conference was called only after the federal judge in the case granted a one-time exception to the court rules barring public comments on the ongoing lawsuit after Johnson City's city manager made disparaging remarks about the female plaintiffs. She used the comparative fault argument. Kathy Ball, the city manager, told reporters that the women were partially at fault for their assaults because they consumed and partook of illegal drugs. And remember, Johnson City is already pushing back against this. They're targeting that 4-year window. These claims are related to incidents from nearly 4 years ago, and the allegations are largely the same as those we continue to deny in other litigation. We have yet to see any evidence that supports allegations of corruption by the Johnson City Police Department and continue to welcome any investigation that could dispel such claims. So we've got a lot to look at, a lot of food for thought. All I can think is we are in such a reverse scenario where usually these same types of arguments that I have highlighted on the screen, those are usually on the criminal side coming from a defendant who is alleged to have done something abusive to an alleged victim. But here it's the city and the police force, the ones that are tasked with keeping the public safe and working for the public, that are saying things like this once again. And it's just such a twist. But with that, I'll turn it over to you guys. If you haven't watched parts 1 through 6 and would like to, I'll link to those in the description. You can check that out. Tons of crazy stuff and a great look at how, the city's trying to handle the PR while all these civil and criminal actions are starting to evolve and develop. Evolve and develop is what I meant to say. And then part 8 will probably be a look at Sean Williams' escape trial and some of the interesting things that he's said, statements he's made in the public, on social media in the past. That might be a live stream. So keep your eyes and ears out for that. And you guys all take care until next time. Bye-bye.